Recording in progress.
That guy? I have no idea. I think he's America's most wanted. He's really chipper and that was my very first picture. I think that I was. Why didn't we put that on the website? You put it in.
So y'all pretty good now? Yeah. Okay. All right, there's no one's in it. Okay, so y'all can't be in. And Nick will be around.
Okay. Are we live and recording?
Yes, we're recording.
Okay. Is Sarah Throne or Bill Hewitt available for chair? Hold on, further here. Instead of finding there'll be feedback if I turn my mic.
That's the only. Yeah, you gotta mute yours. I might have to.
I've got to turn, no, it was mine.
You got it. Now it says the little microphone's been done.
Yeah, let me mute this one in.
It's muted now. Gotcha.
Okay. Can they hear?
Well, I'm the only one that's logged in for you. So, yes, so I can hear you talking. You say something.
It's coming. This is the microphone that's using right here.
Okay.
Okay, so who else is?
That's me.
Okay, well, I can just mute this.
We're live action.
I just muted right here.
Okay, here in Mac.
Okay.
You call room, see if she's joining us. Yeah. Okay. There was a question about.
So they're not gonna be.
The room and what is it? Let's see. Patrick had thought that we didn't need more.
Yeah.
There were 6 of us, so we need one more.
It's typically the majority of the voting members in the body.
A simple majority.
Which is,
Turn this one
We're
off.
on 6. I'd say
Yeah, so I'm gonna,
so.
because I don't think they can hear from way back here.
But,
So I'm, if you on YouTube or then I mute this one?
since the commission adopted the.
Unmute.
Yeah.
Okay.
Okay, yeah. Cause I think they can hear better from.
Okay.
From there.
Well,
What does our act say?
Acts itself is silence. However, let me see. Parameters of livestock poultry.
Dr. Drone said, I'll be joining shortly, just finished with funeral and pulling into driveway.
Oh, no.
Jeez.
She
Okay, you think it's a family friend. So she's in Northwest Arkansas.
Oh, man.
Okay, we'll be around.
Okay.
Anything.
Right.
Okay.
All right. This one, do that.
Said, yes, sorry, we can wait, take your time.
All right, I guess if there's anybody out there listening, we're in pause mode right now. We have,
Somebody muted it. For 5 minutes.
see if you can unmute. Because my mouse is not driving that meeting. I don't think.
Emotionally, okay, too. Yeah.
I mean, I'm hearing things now. Okay, if there's anyone in the public room attending, we're pausing for a one, that'll get our quorum and proceed.
Do you have the file? Or what?
I'm opening it now. I here.
The ones approved or considered.
Two computers.
Check out your question. Report.
Josh, pull up. I've got the section, the rule, and then the docket. These are the rules.
Which one? On the.
Or.
Have some thoughts on it, but on other things, but yeah, I was looking at that, and I was like.
Work.
4, 2, 3.
Right.
Right, that was my thing, they thought we were first. You mentioned that. These two.
That was muted. Somebody must have muted it. Okay. That's how y'all wanna do it. Okay, I'll be like this.
They added them to change the things we were talking about. They were working on medicine.
I don't know how far the range is. So usually that's how y'all usually, you pick up everybody.
I'd be interested on the
Yeah, okay.
Where you have
I could find the bucket in the rule. I have to read out to. Okay, that's where I was headed.
I pulled it up on in that docket folder.
I'm muting your audio or your like. Your volume is muted. Because we're having feedback.
Oh, did you? And you go up in school? So. Oh, you. Yeah. And so they said, oh, so she didn't do. Yeah. Okay. Oh, it's 16. 6 and 8, yes. Yep, you get some cool stuff. Yeah, I like my Monday meetings. It keeps me in that game. Yeah, see like those weird things. I did see this. Where's the medical time? This is where it's 10,000. Is it bothering to be able to stay 24 hours from the last weekend, stay here? Can we do one? Who knows, maybe it's any lunch. We're going to next step. Really is fine.
Hey guys, can you hear me?
Oh, dang. Yeah. Hello, can you hear me?
Hello?
Can you hear us?
I can hear you.
Okay.
Can you hear me okay?
I'm not sure which volume control it is.
I can hear Dr. Niles.
And I can hear you from my machine.
Turn that one down.
I hear a big echo now.
Which one are we gonna need? You gonna keep this one?
Mine is muted now.
Okay. All the way. Mute yours is on both.
Yeah.
And.
So, mute that one here on the table.
Okay, so, and that's how y'all gonna keep it, because keep going.
Yeah, we're gonna keep it that way.
Yeah.
Okay, now turn, how's our audio, Apple gonna go through?
Dr. Throne, can you give us a sound check?
Hello, hello, hello? Can you guys hear me? Dr. Niles, I think you need to mute your computer because you keep coming up as the primary speaker. Now I don't hear anybody.
Can you hear? Can you hear now?
Now I can hear you. Yes, sir.
Dr. Throne, can you hear me all the way over here? Just
I
as a
can,
test?
Tanner. Can you move the screen down, the laptop? I'm getting mostly the ceiling. Oh, now I can see your faces. Fantastic.
Okay.
We wanted you to see the cotton mold that gives. us room
It
to
was
sit
a
in.
beautiful ceiling.
And if you look closely, there's a tiny sticker of a boll weevil, in the cracks there, so that's a little,
So we're
department
having our
history.
meeting in the plant board.
Found the ball.
Underground bunk.
I see the great end of.
Dr. Crone, we very well appreciate what you've done. We just found that you were at a funeral and bless your heart for chiming in here.
Well, thank you.
Okay.
Thanks for let me do this virtually. So it was a family friend's grandma and mother-in-law. So it was nice to be able to be there. So thanks for letting me join virtually.
Gotcha. And you made our quorum and you made our day.
Very good. Even more important. Excuse me. Are we ready to get started?
I'm showing that we are recording and we are open.
Okay. You want me to call it to order?
Yes, ma'am.
Okay. Our meeting is called to order. We'll start with roll call. Whoever wants to start. Sarah?
Sarah Klein, present.
Rob Connor, president.
Kate Williams, present.
Is it just the four of us?
Four of us.
Okay. And staff members present?
Candace Schneeblen, our Arkansas Department of Agriculture.
Josh Moffett, Arkansas Department of Agriculture.
Tom House, Arkansas Department of Agriculture.
Tanner Thomas, Department of Ag.
Very good. We'll start with the agenda items as outlined. Has everybody had a chance to review the June 26 meeting notes?
Yeah.
Do we have a motion on?
Make a motion to approve the meeting minutes from June.
Is there a second? We have a motion and a second on the floor to approve the June 26, 2024 meeting. Any discussion, additions, corrections that need to be made? Okay, all those in favor say aye. Aye.
Aye.
Opposed? Motion carries. Continuing education hours and credits. Candace, can you share those?
Now, you have those on your,
Working on it. Is that in the agenda?
it should be, yes.
Do we have just was there just two? Bring up my other computer. Look at those. Three.
And then other Arkansas.
So there were just two. Dr. Thorne, there were just two.
Okay. Anybody have any questions or concerns on those?
No.
And I believe we do not need a motion on that. They've already been approved. It's just us reviewing, correct?
Correct.
Okay. We have 3 applications for certified veterinary technicians. Beth Ann Odd, Taylor Burritt, and Elizabeth Para. Remind me, do we need motion on approval of these?
Yes.
Yes, okay. That is what I thought. I think everybody got a chance. Let me pull those up. No, we did not get those in advance. So Candace, have you reviewed those?
Those have been reviewed, yes, ma'am.
Okay, and they meet,
They meet
sorry,
all requirements.
often, they meet all the qualifications?
Yes, ma'am.
Did we, I know in the past we've been able to look at those. We brought them up and I don't think we had gotten those in advance. Is that correct?
Not in the last couple of meetings. We started off seeing those packets. And now we no longer see those.
Okay, so y'all were getting the complete file prior?
Correct.
Okay.
For the CBTs as well as the meeting.
Yeah.
It was helpful.
Okay.
So it's helpful just to get that background information so that we know who we're recommending to the commission for approval. So,
We've had a few questions on them in the past, so it's helpful to see.
so if that could become part of our review
Absolutely.
process, I think it would be beneficial for me.
So without that, or I think last time you were able to kind of pull them up on PDF. Is that what we did last time? I'm thinking.
I don't
Or-
believe so.
What do you guys want to do in regards to that?
I think we kind of had the same conversation about we didn't have their name, we didn't have any information on them.
I
But
think previously Kara Clark used to only bring before the committee the ones that she felt
we'll probably,
had problematic
Okay.
things.
okay,
And so,
Or maybe that's what we saw then.
Yeah.
Yeah.
and then on the ones that were perfect or had all the things, then she didn't bring those.
So they're getting properly
so
vetted.
these are all perfect.
Yes,
Right.
ma'am.
Everything's in order.
No questions or concern.
Okay.
Maybe Tanner, if you explain administrative duties. Going ahead and assigning these licenses as an administrative duty, what does that mean?
So. If it's an administrative duty, then it's a responsibility of the agency itself. This committee does take a look at these. Ethical flags, disciplinary, rulemaking, making suggestions on that. And. Also, if y'all will look at these applications, take a look at it, you can request that, you can make sure everything, however, if it is agency or administratively determined, then it's. That means that agency staff have been. Taking a look at it, their commission has the final say, look through these applications and approve and give them their license on that, and. But the agency staff does have discretion on what we do, not pull forward, say if there's any sort of issues or anything like that. I don't see any issue with bringing this before y'all to take a look and different things and whatnot,
Well, we're just approving names.
and then, yeah.
We have no knowledge or history of the individuals. They've been fully
We just
vetted.
know that you fully vetted them and they're in compliance.
And that, that's between y'all and Candace and Corey's Candace supervisor, if y'all want, or if you wanna add y'all responsibility on that, or if you like ways to. But since it is administrative, then it is more agency directed than committee or commission directed.
I think the hard part where we're getting stuck is we're being asked, okay, someone we haven't seen, even though what you, like, you're within your job duties and everything. Because we're putting our final stamp on it and haven't seen it, I think that's where we're hung up. If we weren't asked our opinion on it, it wouldn't matter, because you're doing a great job. But I think it's because, am I articulating that right? Like, I think that's where like my hang up is because I'm putting my stamp of approval on something I've never seen. That's my hang up.
They just leave us out of it and put us in it, right?
Exactly, I think it needs to be like an all or none.
Because once again, we have no idea who they are. I mean, is it curiosity of what the training was, where they're going,
Right,
what they're doing?
right, or like, is there a red flag that maybe only we might notice and look at and be like, wait, what? Coming from the vet field, but I don't know, am I articulating how y'all feel too?
Yeah, sure. I mean, they're being vetted by an agency that's non-veterinarians, technically trained.
Yeah, I think it's the stamp of approval side of things, like, just because we're putting our names on something we haven't seen.
Well, so if, given recommendations, of evaluation of applications, yeah, on 691 or in the code, it's a different citation, but that is within the realm of the committee. Y'all want to continue the administrative review, making sure all the bells and whistles are going on the technicalities, what all that, all of it, or partial, hybrid, or full. That's good to go, you know, but,
Taylor, could you, I had trouble kind of understanding you.
Now that you're all the way across the room.
Shout it loud.
The committee does have the authority to make recommendations to the commission, including without limitation, recommendations regarding rulemaking, disciplinary issues, ethical complaints, and evaluation of application under 17.1 of the licensing statute. So that includes the whole shebang on that. So y'all can evaluate it however y'all want to do so. If you just want to list a name and say, hey, you know, we'd like to do the technical, here's your application, go for all of that and kick that off staff and keep doing it that way, that's fine. Hybrid way, if there's any sort of issues, bring it up to us, you know, let us take a look at it. Or we want to see everything. Y'all can do that.
Here's what I'm hearing to help canvas out. The committee wants to see the full application. When do you want to see that? Before we issue the license? Or are you okay with us issuing the license and then showing you their application after the fact? And you have an opportunity to disagree with our giving of that license. So that's the point we're trying to hash out here.
Sure.
You don't want to just see their name. You want to see the full application. Are you okay with us issuing the license and including the full application in this packet for the next meeting?
Can it be issued as a temporary license pending approval by the committee?
Because you
The
don't
only, the
do,
only temporary license is for new graduates.
Okay,
If we're giving it to an already licensed veterinarian in the reciprocal, it would have to be, well, even with a reciprocal, the only way we could do a temporary for them is called a restricted license, which means they have to practice under another veterinarian, direct supervision. So we don't have a temporary for bona fide DVMs. These are new graduates. They got to separate, they are fully bona fide DVMs, but they're new graduates.
okay.
Temporary only goes for new graduates.
So hypothetically, it was approved, everything looked good from y'all's end, and we caught something, we're like, wait, this doesn't look right. We, for some reason, we don't recommend them. How does that work? Because we already granted it. I don't think it's gonna happen, but.
What the committee gives us, the committee can take it away.
Okay. Okay.
And that's the way because it's seeing the process and how it works, it's going to further delay or inhibit someone getting their license to practice.
Right.
And that's why we're here, and like, we issue it, we, trust me, Kansas, we all checked and checked and checked and checked, and it's got everything, no, you need this.
And this is nothing against you or the processes here.
Yeah,
It's really not.
it's
you
you
guys
who are
are,
doing it?
well,
You're doing
it's,
If she has questions, she'll ask.
it's been both of us, but yes, we are all there to back her up, and we have a checklist. They've got to have this. But for us to issue that, get them up and running, we can give you that full application with this docket. And now you'll have full applications and full dockets to consider. So we'll need to give them some more time. They'll have more to chew on before this meeting. Is that what I'm?
I think with that, I think what Kara did on those first ones is these are the ones that she, scanned them in. These are the ones that I didn't see any issues with. These are, these were recommendations for approval. These were the ones that I had questions that she thinks needed to have a bigger, broader discussion.
And I kind of like that because we had the documents to look at if we wanted to. Because they were in a separate drive. These are ones I didn't have problems with. We could look at them. Yep, good. Here's the ones I did have problems with in a separate, folder under the drive. And I kind of like that because then we could just glance through everything if we wanted to. And like, then we can focus on the ones that did have questions, but at least we had the opportunity to see it before we put the rubber stamp on.
And it's really more for situational awareness, right?
Yeah, that too.
So we can give you the full applications in this docket and give you some more time.
Yeah, we could put them in the drive, kind of like what Kara was doing, and then, but. I mean, unless y'all disagree, I think it'd be fine to go ahead and approve them as they come in, like what you're already doing.
We don't want to delay the process.
Exactly.
Yeah. Yeah.
Because that means they could not practice until the next quarter.
Right, and that's not fair.
Unless we gave them a restricted license, and now we just, we've.
I don't do that. Yeah. No, I don't wanna do that.
But can you just approve them because they've met all the requirements for situational awareness? Either a hybrid condensed version just for our information.
I don't think the same thing as a hybrid condensed version, you either get it all or.
I just make it available
and
yeah.
look at it if we want to.
Because the process goes.
Something goes through AAPSB.
Right. There was like 50 pages of documents there.
What applications are they, just for licensure?
Yes.
But they use
There's the corporate licensors, the new licenses, the reciprocity licensure, there's different application forms for those, but knowing the flow of the workflow in there, they're all scanned in to go into the database. And so at that point, we have them all scanned together. And then we have the capacity with PDF to make it one continuous thing for all of them, or one for this applicant, one for this applicant, and you have every piece of paper that goes with this applicant in a separate file with their name.
Like, that'd be great.
And then another one, everything in their application with their name.
Yeah.
So you go, for me, it would, we talked about filing and stuff like that, we can work on that, but, yes.
Yeah.
So, we can give you the full applications in your packets.
Yep.
For these meetings.
Yes.
Okay.
So how do you guys want to move forward on these three?
I would have tendency to approve them, and then just send us.
Okay, so do I have?
If I may, Madam Chairman,
You may.
I could pull those up. And we can view them, we could move this down the agenda, I can pull them up and you can look at them right quick.
You wanna do that, put it on.
Would you guys like to do that? We can put a hold on these and the veterinary applications.
Let's just approve them this time and
Yeah.
then moving forward, we'll do it. slightly
Okay.
different.
So is there a motion on the floor regarding certified veterinary technician applications?
I'll make a motion to approve acceptance of these three individuals.
Is there a second?
I'll second it.
Okay, so we have a motion and a second to approve the 3 certified veterinary technician applications. Is there any discussion?
And then we'll start with the final this meeting, or do you want to see these? Just for your.
Consider the next meeting.
Next
meeting.
We're ready to vote.
Okay, all those in favor say aye.
Aye.
All those opposed? Hearing none, motion passes to approve the 3 certified veterinary technician applications. Moving on to section 4 of applications, we do not have any corporate practice applications. Is that correct, Candace?
That is correct.
Okay, making sure nothing came in the last little bit. We have several veterinarians that have approved or applied for applications. Do we need to read them into the minutes, Tanner?
sure you bring the names, on that.
Now, Dr. Throne, there was an additional one that was added yesterday. He
Okay.
had a transfer in, but he would be the very last one on the list.
Okay, so we have Olivia Kerrigan, Peyton Clark, Joseph Eastwood, Vernon Langston, Mark Lee, Ellen Malminger, Sarah Mantoviani, Colleen McCarthy, Michaela Olson, Monica Rouge, and Kathleen Sipley. Is the Kathleen the latest add-on, or is there an additional one?
No, ma'am, there's an additional one. There is a Cole Taylor.
Oh, I know Cole.
Taylor?
He's a poultry vet. Any questions, comments, well, before we discuss, I guess we need a motion on the floor for approval and then we can have discussion.
I'll move to approve the list of veterinarians.
Is there a
for-
second?
I'll second it.
We have a motion and a second on the floor for approval of the veterinary applications. We will now entertain discussion. Candace, any issues, comments, questions, or concerns around these applications?
No, ma'am, they've all been vetted and meet qualifications.
Okay. Any additional discussion regarding these from the committee members? Hearing none, I would entertain a motion, or we'll take a vote on these. We've got a motion and a second to approve the veterinary applications. All those in favor say aye. Aye. Any opposed? Motion passes. Okay. We will now move on to complaints. So our first, are you guys good with going in order that they're listed in the agenda, or is there a particular one you would like to do first?
I would like to open with one that has been brought before the commission, if you
Yes.
will allow it.
Docket 2022-16?
Yes, ma'am, that's correct. So docket 2022-16, this was a file that was originally brought up on December 12th of last year, the very first veterinarian medical examining committee meeting. And this had gone for recommendation to the commission to extend a consent agreement to this particular doctor. And consent agreement was sent. She had hired counsel who I've talked on the phone with, and she sent me a letter as well. And they have requested a re-review. However, that's not the reason why I want to bring this back before the committee. I advise the commission to bring this back before the committee, not because I'm making any sort of allegation that the committee has made a wrong decision, or that need to tweak a decision, or need to tweak a difference in punishment or anything like that. It is still the committee's decision to make a recommendation, and the commission has the final decision on this matter. You all have a right to stay the course going forward as to what was recommended last time, what was recommended to the commission. At this point, if a consent agreement was refused, and it was refused to be signed within the 30-day period, candidly and in writing, refused by and through this doctor's counsel, then y'all can go forward. The commission can have a hearing on the matter. We can go through the whole deal. Staff is totally willing to do that. That's our job. That's what I'm going to do. I'm getting hearing set up anyway, and I'm getting my feet wet on learning how to do this and trying to do it right. However, the minutes from that meeting were, I thought, a little bit vague as to the reasoning as to why this decision was made to the committee, not that the committee was. And me and Candace looked high and low for any sort of recording that we had. I remember Carrie used to have the tape recorder deal. I don't think they have tapes in there anymore. But the recording of it, I don't think we could find it. So I couldn't hear what y'all had talked about or anything like that. The recommendation And the charges that the committee recommended was unprofessional conduct by violation of the Rule 19, obtaining or attempting to obtain any fee, charge, tuition, or other compensation by fraud, deception, or misrepresentation. Second was 19O, conduct reflecting unfavorably upon the profession of veterinary medicine. And finally, a statutory allegation or charge of overtreating patients or charging for services which did not occur unless the services were contracted for in advance, or for services which were not rendered, or documents in the patient's records, or charging for services which were not consented to by the owner of the patient or the owner's agent. So overtreating, charging things that didn't happen, doing things that you didn't contract for, unless you contracted for, you had discussions, all of that. The recommendation was 6 hours in CE, 1 hour in client communication, 7 hours total, and added on top of the normal 20. So some things that were not mentioned in the minutes, what I just told you there was the reasoning mentioned in the minutes was these violations are based on the complainant being charged for cremation when the animal was not euthanized, and that respondent's course of treatment for the animal was determined by a call from a friend of the complainant who is also an attorney. The last little clause there I didn't quite understand, and I understand the first part kind of on that. There were things in these minutes that were not mentioned. I don't know if y'all talked about it or not. Again, we don't have I can find a recording. Information not mentioned these, there's an invoice that mentioned contracting for the particular charged services in lieu of others, phone call recordings in which the owner did elect to surrender the animal, the medical record containing subjective notes, plans where it did mention surrender. And there was one thing, I don't know if y'all had a chance to review this. I couldn't find it in Kara Tharp's old OneDrive, which she did give me access to prior to her leaving. There was an expert opinion and a written analysis by Dr. Jared Williams. And I was looking at it, I was like, was this something that? So I looked at that. We couldn't find any old emails that she had sent to y'all beforehand. And again, some of these things, a lot of minutes are summaries, but they do contain sometimes very short and terse reasonings as to what was considered and not considered on this. Like I said, you can do what you want on this. Stay the course, say, hey, let's go to hearing, let's rock and roll, commission, set the date, all of that. Or you can reconsider it. My reasoning and my recommendation to the commission to send this back to y'all was that if this would, the notes were vague, I didn't have a recording. I did not want to set up a hearing with the commission without knowing exactly what I was setting up. We don't have to set that up in minutes. And I don't know, I'll probably talk about this for a long time back then. I don't know what y'all said.
Were you present for this?
I was not, as probably rather around the time I was hired. I started January 2nd, so
Yeah.
that was the AG's attorney that came, I believe, on that. So,
Very first one was an AG
Yeah.
of 20.
and I did him.
We could probably, by memory, run back through.
Yes,
really.
Of course, yeah, run through that, look at the documents, of course, just to make sure. That's what I would like, to just look through every bit of it on there. Yeah, there were some things that you mentioned on invoices where there were notes recorded, different things on that. Just want to make sure that we got everything in there, and the expert's opinion, which I believe was in y'all's packets. It was attached, resent by Virginia Young, the attorney for the respondent. It was attached to her letter. I believe Candace sent that as a secondary email.
I was gonna say,
You can send that.
I got the expert opinion this time. I don't recall seeing that prior to getting it from Candace this time.
Yeah,
point of
order or clarification, whatever it needs to be for Robert's Rules of Orders, that this professional opinion came after the fact and after our hearing. That is, I don't think that's.
The
Yes.
professional opinion was dated February 2023.
Yes,
We
that was
saw
part
this
of
in,
the
like,
original.
December 2023.
Yeah, so we.
And I checked the file, it was, I was looking in there and I was like, the only expert opinion I found is attached to the attorney's letter. Did we have it in the original file? Because I don't see it in CARES OneDrive, I don't see it in our SharePoint as a separate document. It's just an attachment, lo and behold, it was in the file and the physical file didn't have the exhibit mark from the attorney. I was like, oh, well, that is, that's part of the original file, and I'm not exactly sure that the committee had a chance to take a look at it.
So
So
just
it's-
to clarify, make sure I understand, this was, should have been presented to us originally. This is an expert opinion that the board had asked for.
Yes, back when the board was active in 2022, this is one of those
Okay.
complaints that table.
Because it was a 2022 case.
That's correct.
Yes.
Yeah, that's correct.
It wasn't, yeah, so we had no way to know that the previous board had requested that.
But only through Kara Tharp in what she had sent as a review document. And I didn't find it in her digital files, so.
We had an extensive conversation about this at the time, and it was never part of our conversation.
Honestly, for me and my recollection, it would change little to nothing as far as, you know, the expert opinion by Dr. Williams. You know, I didn't really recall having a problem with her treatment of the cat once she took possession of the cat. You know, it was, in my mind, hers to do with as she saw. You know, she chose to immediately do a PU surgery on the cat. The biggest issue we had was, you know, she had charged them for a euthanasia and cremation as well as a surrender fee. And, you know, we all, I think, agreed out loud in the meeting that the surrender fee was not something we were all familiar with, but I think our legal counsel even said, but charge what you want and things like that. But charging to euthanize and cremation for a service you did not do, you charged the client for something you did not do. You know, and so that's kind of the crux of one of the arguments in the complaint is, you know, charging for a service that you did not provide.
I mean, according to,
And
go ahead.
her response was that it would have been a surrender fee, but the medical records did not indicate that.
Right, I mean, according to the medical record, this cat is deceased, correct, which we know it is not true. Ergo, the medical record is not correct, which is where we came up with our responses. My understanding.
Well, and I want to make this clear in what I'm saying here. In clarifying how this law is defined, let's take a look at this. When it is talking about overtreating, not charging for things that were not contracted for in advance or services which were not rendered or documented in the patient's records, or charging for services which were not consented to by the owner, patient, or the owner's agent. There are portions in these bills and records that indicate that the patient might have had knowledge that this was occurring. And also there was were three telephone recordings of conversations where, and this is just me stating facts, making sure that we get our factual determinations correct, that, okay, go ahead. We'll talk about that. One of the, in some of the notes I'm pointing to make sure, and this is, to be clear, state of course, one, not trying to influence this, just trying to point you towards the facts here. Page 17 of the complainant's complaint, and it may be 17 of their overall docket. I don't think those are numbered on this school. I'm sorry, that's the only identification I had. If you kind of look at that little tally at the top of the PDF, you may be able to find it. There is a note stating that the owner elected surrender while paying for euthanasia to go towards the procedure. Phone call, like I just said, they said go ahead, didn't mention anything about exchange for euthanasia or anything like that. Medical record in the respondent's response, stating that there was a surrender and then immediate surgery on that, and I believe, let's see, that, and then Jared Williams, in his opinion and analyses, stated that was. He didn't see that there was misconduct by this veterinarian, and that was the statement from his analysis. Now, if there is something, if you're looking at this and saying, hey, this is not enough evidence to show that these were contracted services, we can do so on that. And I'm not factual determinations and saying, hey, did this occur? What do we want to recommend to this veterinarian? Yes, that's y'all's domain. But as the law states, if there are services rendered that are contracted for between two parties, then they kind of slip past at least 17-101-305 on that. If that's the case. Unprofessional conduct promulgated by the commission, obtaining or attempting to obtain a fee, charge, tuition by fraud, deception, and misrepresentation. Saying if you think, oh, well, maybe she pulled wool over their eyes or anything like that, again, make your own finding of fact, not telling you which way to go on that. Conduct reflecting unfavorably upon the profession of veterinary medicine. Those may be fair game if you think so. If it's, me personally, I may have software that records a discount charge, something different that may be best practice, but legally, my opinion on how I would record things in Microsoft Excel is neither here nor there on that. But and that shouldn't be determinative, unless y'all think so. If y'all think best practice or if it goes against these, I want to make sure that we got a clearly defined issue. She's wired up, so be it. Y'all have to. Y'all got me. We'll get after it. Or we'll do something different.
And one of the biggest underlying tones with this is they're very adversarial issue from the beginning. When the owner was going to euthanize the cat, and the veterinarian said no.
Which I respect right from there, I'm cool with it. Right, but the thing that, and she confiscated the cat, and the thing that soured me on this case was, and of course, the lawyer friend called and said, I'm a lawyer and blah, blah. And Dr. Wendell herself said in the record later, I was perfectly prepared to give you your cat back. You would have been a good home for that. It would have been the best situation for both of the cat. But now that you've consulted a lawyer, all that's wrong. I'm done worrying about the best interest of the cat. I'm now, now we're in the spitting match.
Yeah, they surrendered the cat, she did the surgery, and then when it called and report back to the owner of the cat, did well for surgery.
Now we could reimburse pay the bill.
Right,
the
right,
bill.
the owner offered to reimburse,
Mhm.
and then the additional adversarial relationship occurred when she's there. I have an attorney, yeah, attorney's gonna call her, whatever.
Hey, can you speak up a little?
Or that, if you recall, the Scotties were the owner of both of the cat, and they had a friend that called several times over several days trying to get updates on the cat, and they were actually trying to talk to Dr. Wendell. That was the thing, they wanted to speak to Dr. Wendell, and they kept getting kind of intercepted by the technician.
Yep.
So then, because they had not been addressed by Dr. Wendell, they had a friend, an attorney friend called on their behalf and said, hey, I'm just a friend, but I'm also an attorney. And of course, understandable, I would have been suddenly in defensive mode, but Dr. Wendell kind of went a little further and said, well, literally in her response, I would have given you the cat back. The cat would be at home with its buddies, and you could pay your bill and take the cat back, and we were going to work that out on some level. But now you've involved an attorney, so now suddenly the best interest of the cat took a back seat to, okay, well, we'll just go, we'll fight this out with lawyers, so to speak. And that's the end. So that was, I think, one of the big determining things for us as a board was, wait a minute, we went into a spitting match, not what's in the best interest of the cat. I respected Dr. Wendell for saying, let's not euthanize the cat. If you'll surrender the cat, then I will do everything within my power to help your cat. I could also understand the Scotty's side of the argument that we made a big mistake. We don't even know if this is the cat that was having urinary problems to begin with, and we overreacted. We're so terribly sorry. And Dr. Wendell, if you recall, recorded those conversations. And honestly, reporting it as harassment, it really, to me, sounded like two sweet little old people begging her to, could we
Desperate.
please put something out about our cat? So it was, in my mind, not harassment. It was more, it sounded more kind of unprofessional on the veterinarians end.
Because a lot of times when animals are surrendered, an out plan goes into effect
Yeah.
pretty quickly to try to get that pet rehomed, relocated, something. So I could see someone being like, oh my God, I need to get in touch with this doctor before they rehome my cat,
Mhm.
you know, and there's this emergency.
So the first thing that you went over, you had the three
Yeah.
individual findings.
We charged for
I
those.
think number one, maybe something that we could
They have to drop that.
drop that one, but there are the other two.
There are
Three.
so
Yeah.
The comments that I had in my notes, I'm looking back through, and I don't know if this helps, hurts, but I'll read what I had, was just, there were kind of three areas that we had concerns in around communication of the whole idea of surrender, euthanasia, what did they pay the $301 for? And clinics saying that's a policy around surrender. Euthanized, but they were charged for it, but the cat wasn't euthanized. Surrender, just that communication, explaining what that means and what that entails and the details to the owner. The comments that I wrote on in details around the actual rule violation was the violation of 101.305-11 unprofessional conduct. The 19-0 were the charges for euthanasia and cremation when that didn't happen. O, which was conduct unfavorably, and it was the whole idea of changing the course of treatment, or the course of treatment was determined by that call from the attorney versus considering the welfare of the patient. And then we had the A-15, which is overcharging of the patient, charging the patient for euthanasia and cremation in addition to the surrender fee, when really all they did was surrender. And I think, quite frankly, if they would have just done the surrender fee and upped their prices on their surrender fee and not done the euthanasia and cremation, that would have been a lot more accurate in their medical records.
Right.
But that's what I had in terms of my notes. And then we had the conversation on page 7 of 17 in the official answer, in the plan, she had added notes in there that were obviously after she got the board complaint. Because it talked about, I don't give permission, all this kind of stuff. And so there was this whole idea of changing the medical record.
Yes, it does. Getting those things down, and Dr. throwing those notes actually do kind of put things in a little bit more context on that. And let's see, so like Dr. Throne said, the charges as it stands right now are recommendation on this: obtaining or attempting to obtain any fee, charge, tuition, or other compensation by fraud, deception, or misrepresentation.
I think we're going with the misrepresentation.
Yeah. Conduct reflecting unfavorably upon the veterinary medicine, overtreating or charging for services which did not occur unless the services were contracted for in advance, or for services which were not rendered or documented in the patient's records, or charging for services which were not consented to by the owner of the patient or the owner's agent. So that statute's written very confusingly. It's tripping me up every time I read it. So overtreating, number one. Charging for services which did not occur unless they were contracted to for in advance. Number two. Or services which were not rendered or documented in patient's records. So ghost charter services that you just did on your own, not reported. Number 4, charging for services which were not consented to by the owner of the patient or the owner thing. So it's 4 separate BO statutes. So on that. And to make sure stuff like there was one invoice in the complaint that was submitted that did record that the owner elected to do euthanasia instead of rehoming fee on that. There are other things to take a look at, just factually speaking on this. Well, y'all mentioned it just a second ago, the notes and the plan and the subjective of a medical report July 18th. I wrote that down. So.
July
I'll
18th.
take it on this, these notes here, 10:45 a.m. visit with veterinary Lindsay Wendell for AER possible blockage. I think on that. So were there notes added that you see on a date or like later on the further or and I'm looking at respondents' response. Talk about owner call and different things like that. Discuss possibility of surrendering Mocha to us instead of euthanasia. I was willing to do this, and we will call them back with next steps of surrender. Called again, 10:20. Urgency that Mocha quote can't be just plots. Kind of describes a lot of the kind of details of what's going on, corrective surgery, what they talked about. Pretty much in that phone call covers the same ground if I remember correctly. Let's see. Plan surrendered Mocha for immediate surgery, surgical procedure notes to be provided at board's request. I do not give permission for these notes. Details to be disclosed. Is that notes to be provided at board's request? I do not give permission for these notes and details to be disclosed to the Scotties as they are no longer his owners. Also do not give permission for medical notes for any of that. When you're talking about notes added later, is that the phrase that you're looking at right there, remembering? Do y'all?
Yeah, I think that was part of it.
Because I was trying to find on these records, sometimes you can see, I remember in my old personal injury job, I've seen 1,000 medical records. Sometimes you can tell when somebody has typed in a note depending on what software they're using. That's why I'm.
In Dr. Wendell's kind of address to the board, he said that sadly, as you know, one of the most common reasons for feline euthanasia is urinary indiscretion, which means that urinating in places you shouldn't. Euthanizing healthy or treatable animals is one of the main reasons contributing to the awareness of veterinary suicide, basically. And having to enduring bullying from clients is kind of one of the things. Well, their letter said, you said that he needed this life-saving procedure that he may not survive and he was in severe pain and distress, and so we elected at the time to euthanize. So it's two completely different prescriptions of, perineal ureterostomy surgery is considered a salvage procedure. It's the last option you have before you euthanize. There is no guaranteed outcome. There are all kinds of potential lethal, predisposing factors with it. To me, it would be reasonable for them to have told the Scotties, look, this cat needs this surgery, but might not survive. And it would be reasonable if you're the Scotties to go, well, goodness, if he's in pain, he might not survive. It's $3,000, and we're gonna elect to end his misery. Let's do the humane thing.
So we can go through the surgery and he can block again,
Or he could,
even with a TU.
so their responses seem so reasonable. As we read through some of these other cases here in a while, you go, well, there just does not seem to be a lot in Dr. Wendell's response that I respect. I want to help a cat. That's why we all went to school. That's our passion. But then these are very good clients in a way, as far as they rescued the cat was sick, paid all these vet bills, previously with Dr. Lynn's clinic. You know, so there was a lot of good faith there, in my opinion, until the lawyer friend called and went, you know, and it triggered something in this veterinarian that like, now we're not going to work toward a common goal. We're going to now, we'll see you in court. You know, it's kind of, and so, yes, see the threat, and then now we're not going to be reasonable. You know, and prior to that, it just seemed to me like the Scotties were reasonably sad, that they weren't trying to be punitive, even they were just trying to undo a bad decision. So it's kind of the place we all came from when we came together on these different charges. So go into your job as far as trying to support legally,
Right.
he said, she said.
There's also something to be said, you know, when you see like consented prior to, and then down at the bottom, there's a little note to the board in the medical record. And like, what else was changed? If we can't stamp that plan was changed to say provided at the board's request, like at the time, she didn't know this was gonna go to the board. So obviously that was added in. What else was changed? What else could have been changed? You know, it says kind of adamantly that the surrender decision was made and euthanasia was off the table, but it's like, did you add that after the fact? Is there any way for us to know? Like, I don't know if we can prove it one way or the other, but that sends up some big red flags to me. That the medical records may not be accurate if you can go back and add in on something from September 18th with no timestamp. That bothers me. Yeah, I mean, if she had done it as like a footnote, like no added on blah, blah, blah date pertaining to this record, hey, if the board needs to see this, that's honest, that's transparent. But I feel like this isn't honest or transparent, which makes me question other things that I'm seeing.
What's your advice, Taylor?
Well, and
Yeah.
here's on the two rules, you know, that kind of is up to the veterinarians, you know, procedure, because it's, y'all are there and make recommendations on, you know, I want to be clear, especially here on this statutory allegation here of overtreating, charging for services did not occur unless the services were contracted for in advance. So when I'm thinking of contract, I'm thinking of what I learned in law school. You've got offer, acceptance, consideration, but you got a contract. Not just a random promise. It's not just hey, swing by, I'll give you my bike or anything, you know, something like that. And then services actually rendered on that. And if what I want to draw attention to, if an invoice dated from the date of July 18th when surrender and the surgery happened, again, I'm not allowed to do that, but it's after some emails on the complainant's complaint form. And I believe it's the last invoice, but I'm not exactly sure.
For the exam, the bladder ultrasound, the radio.
Yes, exam, urgent, yeah, and then euthanasia and the basic cremation. In a note there, it says owner elected for life-saving procedure. O agreed to pay for today's exam, radiograph, and ultrasound to determine urgency in the originally elected euthanasia costs or funds to go towards this procedure. Patient changed to hospital staff in medical records because of the surrender. That balance is zeroed out, meaning that it was paid that day, likely on July 18th, 2022. We've got, it's if you have, and when I'm thinking of evidence, just across the board, in any sort of Anglo-American common law jurisdiction like the state of Arkansas, it's any it's any document, information that makes a legally determined fact more or less probable. So if I see Dr. Niles fall out dead, and then I see him 3 days later, and I see 11 other people see him 3 days later, and then 500 people see him 3 days later, it's like, we've got reports here if somebody going back to life. This is an analogy that we already know from being in the state of Arkansas, carried over there. That's an example of evidence. You may or may not think that that's a likelihood. You may not think that that's a belief that you should hold, but it's evidence that makes a certain fact probable or improbable there. As a committee, y'all are to make recommendations as to actions that on disciplinary matters. If you think that these facts comport with what you've seen in these, take a look at these. And all of that is to say on the statutory one, it references records, invoices, things specifically. If we are going to stay the course on this one, at least they have submitted the responses, and both of them are very passionate about their side of the story. And that doesn't make it here or there because they've owned that skin in the game, you can consider it, weigh it, and it's part of it. But on these, when it references records, different things, that needs to be taken as a whole bundle there. And I don't think that we can necessarily rely on only the statements of either party in making a determination on that. If this is enough to say, hey, it looks like they have a contract for certain services, I wish you had a different reporting software to make it a little bit clearer when you give somebody a discount, then that's it. Or do you think, well, they're mentioning euthanasia, they didn't mention cremation in that note. Well, that may be one service that's not contracted for, or might be implied, or anything like that. These sort of factual matters, I think that this is determinative and could be substantially supported by evidence, which is a lower standard than probable cause, probable cause, preponderance of the evidence. That's a civil standard, kind of a 50-50, 60-40 type-ish deal. Ours as committee and commission is a little less. If you think that when this goes before the commission, you think that they can prove this in front of there, and think that, or at least we'd like to investigate it and see, we don't like the conduct here. Otherwise, other than that, we just need to be clear. I want to make sure that we do consider these sort of things that necessarily weren't mentioned in these minutes, and I didn't hear anybody talk about it because I would love to be on the fly on that. That would make my job a little easier. If there's no recording, that would be fine on that at all.
Do you think one of these would be defendable, 2 of them, or so would you, just from the legal side of things, would you drop 1, 2, or all 3 of these? Please, just from what you see and what you backed up in writing legally, if you were just on whether you win or lose, so to speak.
Rule 19.0, conduct reflecting unfavorably upon the protection of veterinary medicine. That is by veterinarians for veterinarians. If that is, as far as I'm looking at that one, if all of this is 100% Jones call, but if anything of this is 100, like 200% Jones call, that's the that's y'all's.
Okay.
On that. So I'm not going to issue opinion on that. It's y'all's decision on that.
Okay.
Obtaining or attempting to obtain any fee, charge, tuition, or other compensation by fraud, deception, or misrepresentation. Yeah, looking at this, I don't know if this is exactly fraud. But you also have the terms deception or misrepresentation. If y'all think, after remembering and going through looking at these records here, if the owners were shaky on something or something was misrepresented, if you think that there was 2 ships passing in the night that may rise to the point of misrepresentation, or you want to investigate, the commission hearing can actually, as part of this, they can submit either side their own evidence if they want. Scott can testify, and the commission then has a position to determine credibility of witnesses as well. Even if you're iffy,
If it triggered a hearing like that, and they chose to show up, and Dr. Wendell would be free to show up as well.
yes.
In their own words, in the commission.
And that's another reminder I've got to remind myself coming here from private practice. I'm no longer a plaintiff's attorney. So we're not bringing this before a judge, commissioners still talk during the thing and ask their own questions. Fact finding, and everybody can submit their own briefs and evidence on parties and all that. The vet does have that right if she's learned up in it, and I will do the extent of my job to bring the best evidence. I will always do that, but it's not my job to push their way or to represent y'all or think.
Do you think that the lack of recording and incomplete files that were presented to the committee, if that comes out, is that we can?
Weaken your argument.
We could, the argument.
I would say no, because we're talking about it right now, and that recording button it's hot, it's ready to go. It's not ready to go. It's going right now. You know, we got it recorded. Y'all talked about it. Y'all talked to me about it. I've read through portions that red flags to me, just kind of wondering, hey, was this considered? Was this expert opinion considered? Was that I didn't see before? So that, again, to emphasize, I'm not trying to sway necessarily. And it's at least on a recording, you know, on this. Factual determinations are also getting on this committee. I'm doing the best I can to detail the law, things that I saw that I want y'all to look at, listen to, all of that, make sure that we do this. If we do this, I'm going to balls to the wall. That's the hearing. Again, not really going no longer.
I think that's precedent as a committee that if you lawyer up and you contest something with this problem. You know,
Yeah, sure.
I don't want to set you up for failure, and I don't want to, but.
I would say maybe consider dropping the charges part of it. I think that weakens our case overall, because that's our most shaky ground. And if we dropped our kind of shakiest ground where someone can say, well, it's this year.
Unprofessional
And
conduct.
leave it at the unprofessional conduct, the communication, that where we're stronger. I think, A, it shows that we're willing to reconsider, you know, fairly. But B, we're also gonna stick to our guns on the things that we believe in. And maybe then that will also remove kind of the shaky part of your case. And you know, you would still have the ammunition for the rest of it.
Yeah, and it's not me talking about me not wanting to take a shake.
No.
The shakiness came from the minutes being kind of vague to me, and recording of this at the time. I don't want her to take this before the commission without hearing from y'all, because I didn't think I heard from y'all on these minutes on this.
Because our recommendation was only CE.
Right.
Well, I think too, I mean, based off what Candace has, provided more detail, that Candace, thank you for doing the more detailed, that was a huge help for me. I don't know as if you got all of the information recorded that we had intended information, because I have 17.101.305-11, which is unprofessional conduct, and then 19-N, which was charges for euthanasia and cremation, 19-O, conduct unfavorably changing the course of treatment based on that attorney versus the welfare, and then 17.101.305A-15, which was the overcharging of patient or charging of services not rendered. And that's how we arrived at hours of CE for record keeping plus 1 hour of client communication in addition to the regular CE. So are you thinking, Sarah, Dr. Klein, that stick to just the 19-O conduct unfavorably?
Yes. Yeah, I am. I mean, do I like how the records were? No. But we only have what we have here, and there are a few things that do show that they were talked to and that they agreed to the surrender and that they agreed to the charges being applied as they were. Even though those are incorrect charges, the owners did agree to it. And I think that's what makes it shaky is, our point, and we can explain this all day long, is that your charges are incorrect. What your record shows that you did to this cat is incorrect. But because the owners saw that and said, I get it, I agree to it, apply those charges, I think that's what makes it shaky. Does that make sense?
So do we need a motion?
We would need a motion.
So what
If
exactly?
you guys are comfortable with that.
So, that would be.
It would be. Okay.
Yeah, the whole intent of this committee is to, if we have a citizen, maltreated, mistreated by a veterinarian, that we hold that veterinarian to a standard. We try to do everything we can to make things right by that citizen. You know, and so I think our intent is to direct this veterinarian to kind of conduct themselves more, better communication, more less litigious or at least less venomous, you know, and more, you know, caring in the nature, the nurturing and stuff of our profession. I felt like it was very good in the beginning on this case, and then it just went off the rails. And it was just so, I think if they put that much effort in the second half of Mocha's communication as they did at the very beginning, we wouldn't be hearing about this.
Since there is talk of kind of a strange happening in the record where it says board on that. I don't know if there is in the original charges, there are record keeping violations. Let me pull these up. If we want to focus, or if y'all want to focus specifically on records. Excuse me, sorry about that. Let's see, give me 1 second. There we go. The statute. Or as part of that, wait, hold on. Maybe I'm pushing myself not here. Continue, yeah, 6 hours of continuing record keeping, that's already what was recommended.
That's what we're.
Yeah, sorry about that. Gotcha, that's where I was getting myself turned around. I was like, that's not in charge, but it's part of the things that you can recommend, so.
And we,
no,
and we,
I got you.
you know, we did initially recommend 6 hours of record keeping, which is quite a bit compared to what we've done since. If we wanted to stick with record keeping, maybe make that adjustment, to lower the amount of additional CE.
And also to add another wrinkle and complicate this further. Y'all wanted a lawyer here, you know, so that's what you get, you know, complicated things. So is it a recommendation to suggest another consent agreement or to charge this veterinarian and go to a hearing on this? Because if we're changing the suggestion as to hours or anything like that and lessening that, and that's in taking away certain charges, if you take away charges, the same thing going to the hearing on that to see what happened, see if you prove conduct reflecting unfavorably on the profession. But if we're suggesting different consent agreement hours, then that's are we offering to do consent agreement. So as it stands, first consent agreement was stated reasons in the letter. After that, it said, hey, you know, don't do this, we'll consider going to hearing. That's part of the consent agreement there. Now we brought it back to take another look at it right here to make sure that we're all clear on what's going on. New consent agreement or go through with the original hearing process since there was a refusal. That's part of the decision. That's not sentencing, but penalties, so to speak.
Do we have a motion on or thoughts on what we would like the motion to be?
I was just saying that consent agreement. But if we change any hours, can change anything. It's a new consent agreement.
Well, you have an option to do a consent agreement. If you think you want to retry and say, hey, here's another agreement. If you want to take a look at it and do that, here's what we have and have not changed with less hours, and we've taken off 2 things.
Taylor,
Yeah,
just
so
so I can make sure I understand. So we gave our recommendation to the commission. Then it came back to us. Nothing has been sent to the veterinarian. Because it's
consent
just
agree-
bounced between us and the commission.
The commission approved the offering of a consent agreement to the veterinarian. I drafted one, it's sent, they have 30 days to agree to it. And it was a candid, not just a flippant refusal, but they have their thought out refusal on that with council. I'm not gonna sign this because I don't think I did anything wrong. That was their statement summarily. And as part of those consent agreements, say, hey, if there's refusal or neglect of this, the Livestock and Poultry Commission probably will or will elect to have a hearing on this issue. The commission can stay out of that if they want to. Or in this case, they listen to me back in July and send it back to y'all to make sure that we're clear on these issues here. At this point, as the power of the committee to make recommendations that y'all have, if you have several options here, if you want to stay the course, this consent agreement was refused, but we want to submit a new recommendation to go ahead and go through a hearing with some or all of the previous issues or charges and the same amount of hours and punishment suggested as a result of this. Number 2, you can offer an amended consent agreement to then be approved by the Arkansas Livestock and Poultry Commission with a little bit of changes. Give the veterinarian, after the commission voting on this, another 30 days to execute this agreement, should they so think it's good. And if that doesn't work on that one, well, that's 2 consent agreements, then we'll just go to a hearing. You can do that. Number 3.
Okay, so just let me make sure I'm understanding, because I'm going back to our agenda for today, and it said this in the summary. The docket was previously heard, sent back to the committee from the commission. So there was a consent agreement sent to the veterinarian. So
Yep.
in order for that to have happened, it was approved by the commission.
Yes, to send that consent agreement. It was an offer by the commission to this veterinarian.
Okay, so committee made the recommendation for the consent decree. It went to the commission approved it. Therefore, it got sent out to the veterinarian.
Correct.
So when did it get sent back to us?
In the July Arkansas Livestock and Poultry Commission meeting, because that was
Okay.
the next. Because it was brought up among other complaints that had either neglected or refused consent agreements as well. And the process is, well, the commission can decide on what to do. It really has the power to drop all of them, but that's typically not the process on this. Several other of the consent agreements that were not signed or returned to us have been set for hearing in early November. 6 of them back to back. And this one, since I looked at it, I'm like, these minutes are not anything I can work with on this, and I want to make sure that you're from y'all.
Okay.
Story deal today.
So it went to the commission originally in which commission meeting?
Originally, I think that was in January, and God, goodness gracious, when was that? It might have been during that big old snow day. That period
Okay.
that we had.
Okay. And then it came back to us in the July.
That's correct.
Okay.
A lot of time since it was first suggested, and that's just the nature of what we're dealing with the committee and commission structure now.
Mhm.
This complaint is 2 years old now.
Yep, yes. It's been around here for a while. You're the only thing where I think.
Okay, just needed to get clear. Excuse me, guys, sorry.
So what option would be?
Next steps.
Everything else, punishments or the, what we, our recommendations, and then just withdraw two of the complaints, right, 2 of the violations, just let it ride at that.
And
then,
what I was saying with that, there's 2 ways you can do that. Hey, we're saying, hey, commission. Consent agreement, or you can say, hey, commission, let's have a hearing on it, but with less issues on that.
It's a consent agreement.
Yeah, they say consent agreement, yeah,
Mhm.
drop the 2, keep the same CE.
Okay.
Or would you adjust?
See if the veterinarian's willing to accept that, and then therefore not, figure a hearing if necessary.
We're asking for 6 hours of CE.
Sarah, are you hearing that?
It was kind of muffled.
So
Of course.
what I said was to consider a consent agreement, drop the 2, keep the unprofessional conduct. And then we decide, do we keep the same CE or do we adjust that?
Okay, so when you say drop the 2, which were you thinking?
That would be the rule 19N, fraud, deception, misrepresentation. That one's, and then the statute 17-101-305-A15, overtreating charges for things that didn't contract on it.
Okay, so keep 17-101-305-11 unprofessional conduct, and then going into 19-0 conduct unfavorably.
And the CE that we requested was part of medical records. There was a medical record we delineated, 6 hours of medical records. Which we kind of still all agree there was a medical record issues, and then a communication
Yes, for total 7.
for total 7.
Yeah, we had 6 hours of record keeping and 1 hour of client communication.
4 hours.
4 hours of record keeping and 2 hours of communication.
I agree with that, actually. Yeah.
Because it emphasizes it is a communication. It's a communication that leads to unprofessional conduct, which leads to the basis of a lot of this adversarial relationship.
I mean, medical records will be your internal communication, and then your client communication is your external. I think that's good.
Well, it's interesting too, before you just crash I was charged for a service that I was not aware of, right? If you look in I thought it was in here somewhere, and in the rebuttal by the Scotties, they said on July 27th, they called to pay their 301 invoice over the phone. So that invoice was generated afterward and said it was a $300 invoice and had to process the payment, but did not send us an invoice. So they didn't know what their charges were, and they didn't know what their total was. I was trying to remember, we were so hung up on that. Why do we believe these people that they didn't know they were being charged for cremation and euthanasia to be put towards the cost of the PU surgery? So they stated in their thing that they called Taylor, the receptionist or office manager, and they said, "What do we owe you for?" And she said, "You owe us $301, that's your balance."
So they never saw.
They never
this
saw the
before
invoice.
notes On it.
Oh.
Anyhow, that, I was trying to remember why we gave some credence to the Scotties, we didn't know about that, we declared that being in fraud, or that was a deceptive fee. It was, they paid after the fact, on the phone with a credit card,
I never saw their
never
invoice.
saw the invoice.
Okay, I'm going back to the original.
Anyway, I'm sorry, I didn't mean to last plenty of water, I was trying to remember why we thought that was so
Yes.
unreasonable.
And
Yeah.
can you see why I wanted to hear from you already?
Yeah. So
That's why,
that was,
to get that.
forgotten about that assertion that when they did not pay on the day they were there, there was not an invoice generated put in front of their face. Here's your total, $301, and it involves these services and these charges. It was, we called a week later and said, hey, while we're busy trying to get our cat back, what do we owe you? It's $301.
Ergo.
Yeah.
Such a great,
So-
the second one back in.
So again, if I were the Scotties, I could see how they felt like, wait a minute, you charged us for something that we didn't realize that. Like we just paid a total, we paid a total on the bill, not, and again, possibly just semantics, so,
Well,
but that's why we felt the way that we did. I remember the why.
Right.
and, evidence flow without. I can substantiate that, those different things as well, that you, that commission.
That one would be. if
Yeah,
I
that a commission
added that
report, if you didn't have, already,
I added that other part of my invoice for about what.
if you saw like our best bank charge,
Yeah.
for a certain date. No problem, but, then if you, again, options are state of course, state of course, to the state of course, want to reference that hearing with the same amount of charges and suggested penalties that we did from the very start. State of course with a hearing, different penalties, different charges, however you want to do that. New consent agreement with different charges and slightly adjusted penalties, or I guess you can do a consent agreement with the same penalties there. So you got two hearing options. If you want to change the violations there, stay the course, edit the course a little bit. Or if you think that this is something that needs to go out, then it needs to be brought out in a hearing with witnesses, sworn testimony, briefs, records, bank statements, anything else you want. The commission has also subpoena power. And in my opinion, I think that, actually, I think I have subpoena power as well, to figure out evidence and different things as well, so.
This paid invoice of that 301 was provided by Dr. Lindo, not the complaint.
There's one that is on the first complaint that includes that 718 invoice. I'm trying to remember
This is one,
the
it
complaint
says-
being submitted by the complainant. The response, I don't know if it is on the response, I think it is, provided. But the one I read with the note talking about what they decided to do on the invoice was provided by the complainant. The veterinarian, the respondent in this case provided, a narrative of, and not just narrative, a record with the different dates of the first start of treatment at the very end. And then that rebuttal where they said that, hey, we paid for this later on this.
Just thinking what I think you're looking at.
yeah, after receiving the invoice on invoice 2864, he called back to talk about it. They paid it, then they got the invoice, then they called in.
And
Well,
a hearing is reasonable, I think there's thought.
Well, that was my thought, is that let them both show up, tell their side, and then let the commissioner, or whoever the appropriate authority is, judge on the merit of that. We've got a few other cases that total opposite, he said, she said.
Yeah.
I mean, you can't both be right when they're that wrong. But in this case, I mean, I would love to have the veterinarian and these clients in front of me telling me, how reasonable or unreasonable they are, because it really seems like I would look at, if you heard one side of either one of these arguments, you would think it was reasonable there.
And credibility is a very important determination in Arkansas administrative law. I can tell you that. It's very dispositive in workers' comp litigation, which is before a judge, but commission still has to determine the credibility of witnesses. Whereas that is not as much of an issue in civil or criminal law, that would be a jury's decision on that.
The other thing that, they talked about in the complaint after the whole 301 charge. Upon checking today's charges include euthanasia bundle charges, we actually have a surrender charge, but it's much higher than a euthanasia charge, and I feared you would choose euthanasia. I have yet to work in I mean, it's been a long time since I worked in a practice, but that you don't have the option to choose surrender and change the price. So if that's the concern, charge your line item for what it is, adjust the price. You can adjust the price in any of the systems. I've never seen one where you couldn't. You guys correct me, you're more connected to it than me, but.
Something else I'm noticing is in the complaints letter where it says July 27th, 2022. I called and asked a third time for an invoice for a Mocha's visit. Upon receiving the invoice, and it talks about the charges and says, we never discussed or agreed originally elected euthanasia costs for funds to go to procedure. Then also says stating we needed to pay for the July 18th office visit. How much do we owe them? I paid the 301. If you look at their records, under Spot City where it says transaction date, it says payment made 7/18. It wasn't made 7/18 according to their records.
Yeah, right. Again, if you had a credit card receipt,
Right.
when was it charged to your account? That would clear that up right there.
You're saying this,
Who's accurate?
this is incorrect. That,
Yes, this is incorrect.
7/18, yes.
it's 7/18, 57 payments, so
Because
that's
if the
that would be
owner
made record.
is still on the 27th, it's saying, hey, I haven't paid this, I don't agree
Right.
with it, but then I did pay it, like, why, how did they get a
Right.
payment?
The invoice
9
dates
days
is
earlier.
7/18.
Okay, I'm gonna amend what I said earlier. I think we should stick with what we have and send it to the trial. If you guys agree.
Are you putting that in the form of a motion?
I will put it in the form of a motion. I motion that we maintain the charges and the remediation that we stated in the original docket case.
I would say that.
Just let me make my notes.
If I may, we've got this on the screen now. There was a point of contingency as to whether they knew what those funds were going for. And here's the doctor's medical records that's saying that the euthanasia costs and funds go toward the procedure.
Yeah.
Right, but the owners never received a copy of that invoice until after the fact.
That's the point of contention.
Allegedly,
Yes.
you know.
One of the central points of contention in here, yes.
So the doctor seems to have documented the fact that they understood that's what was happening. The owner doesn't understand that that's what was happening.
Exactly.
It was documented that day.
The owner states in their file that they never received that invoice. So you can create all the documents you want, but you don't see it. Yeah. Okay.
So we have a motion from Dr. Klein, and I believe we had a second from Dr. Connor. Okay, so let me restate. We have a motion and a second from Dr. Klein and Dr. Connor to maintain the current consent agreement along with the recommendations for, what's the right word, Tanner? Not punishment, but action.
Here's the deal with the consent agreement. Make sure if we extended a consent agreement and part of that as a refusal or neglect to sign within 30 days of receipt of this, which we have by certified mail, then this will go before the Arkansas Livestock and Poultry Commission in a disciplinary hearing for the special hearing. And if you want to stay the course with that, then that needs to be part of the motion. And I think that's what you were trying to get at. But y'all can be nice and offer it again if you want, but I'm not exactly sure that's what you meant. You have to really do that.
No, I think we should send it on to the commission and then the attorney side. of
Yes,
things.
you said the word trial. That's right. That was
Yeah.
part of, I remember that. So go through with the hearing
Yeah.
instead of offer another consent agreement.
Okay, so maintain the current consent agreement and move forward with the hearing. Are you amending your motion to reflect that?
Yes.
Okay, so we
Okay.
have a motion and a second to maintain the current consent degree agreement. And move forward with the hearing, recommendation to the commission. We have a motion and a second. Any additional discussion? Hearing none, call a vote. All those in favor say aye. Aye. All those opposed? Motion passes.
Thank y'all for, looking at that again. Just to
Oh,
hear that.
yeah.
Yeah.
Sorry for all the confusion, because it is.
This-
amazing.
Well, we review the minutes. And if the minutes don't reflect our intent and the verbiage, then we need to be more proactive in it to make sure that it does.
And having all these.
I got what I wanted, and taking that back to y'all, so,
Awesome.
which is mainly, you know, what's that?
And we learn from it.
Yeah.
That was one of our first ones that we did, so we weren't maybe not totally first yet.
Before we, the next one, we were gonna go ahead and break for lunch.
That was gonna be my recommendation, cause I rolled in hot and I'm hungry. How long do you guys want or need?
I want to throw 30 minutes.
Yeah.
Yeah, thereabouts, or, you know, we can even.
Yep, so how about reconvene at 1:15?
That works. Sounds good.
Perfect.
Deal.
See you guys in half an hour.
And then we're gonna
Positive.
pause recording.
There's a lag to it.
Recording stopped.
Are you guys there?
Recording in progress.
And sound checking, Dr. Throne.
Here?
I can hear you. I can hear you.
All right, we are back, online again. Tanner has excused himself for a few minutes, so we'll pop back in. I believe we can.
Totally unacceptable.
Unacceptable. That's right. Proceeds,
Ready to keep on? Ready to keep rolling?
yeah, there's plenty of watermelon here if you want some.
No, it was delicious.
Pardon?
There's plenty of watermelon if you want some.
Oh, darn it. Just 3.5 hours away and I'll go grab it. Don't be jealous, but I had leftovers from last night, so. Our next case is docket 2024-04. And this was a tabled case from the previous meeting that we had. And it was tabled pending an inspection of the clinic. Do we have an update on the inspection?
Am I unmuted still?
You are unmuted.
Right, yes, Dr. Moffett and I completed an inspection of the clinic. He designed a very nice form, based on our facility inspection rule. And we went through it line item. Overall, the general facilities were satisfactory. Laboratory requirements are satisfactory, surgery requirements are good, except we did note that it was off limits now because they had a ceiling tile damaged and they weren't operating in there just yet. They had a temporary setup in the surgery prep, which had all of the capabilities of things that they needed. We did find out in that surgery room that the tabletop was not impervious. So that was unsatisfactory and they were taking actions and ordering up a new tabletop for that. They did get a ding for radiology area because they did not have their dosimeters on hand at that time, but they were on order. So overall, everything was satisfactory except a few little minor things like that. There were a couple of expired drugs in the pharmacy, so we asked them to go through their pharmacy and update their drugs.
Clinic was clean, the client facing testing and stuff declined.
Correct. They had adequate facilities. I mean, it had your standard. We were there toward the end of the day.
Sure.
You know, and there was,
Yeah.
you could tell there wasn't an accumulation over there. There wasn't any overwhelming smells or accumulated dirt, piles of right, like that. So
it's, I mean, these allegations that his office was nasty and that these were, that.
The tier testing was falling
Tier tests,
apart.
yeah, so it crumbled and fell apart. I mean, the facilities at least did not bear that out.
everything looked like it was adequate. It is the structure outdated? Yes. Is it, a standard of today with, open windows and everything? It's an older facility, but it's fully functional.
Okay.
Fully functional, and we did not see anything offensive in there.
You were allowed in, like.
Absolutely. We had, plenty of, we met the doctor and he welcomed us in and had us escorted around.
Okay.
And he would have gone with us, but he's just a cabin with weather right now, so.
Okay.
Sparing the details on that.
All right.
But overall, they were very receptive, the staff was very receptive.
Excellent.
They responded well to everything that we pointed out. And we fully expect they'll have those done. Call back and say, let us know when you get them. And try to get those pretty soon. Those details were pointed out.
Positive. Yeah. Something, yeah.
The other reason we noted to table it is a witness letter. Did we get any additional witness letters on this case?
Do we request additional witness letters?
I had written that in my notes, is that we were gonna request additional witness letters.
Is that a specific witness or just overall witnesses?
I think we had, I think specific, well, I didn't write any specific in there. I know there was a list of persons who can confirm all or part of this. Was those three, plus you had Dr. Drake, which I don't believe we had. No, we did have that. I just wrote down that we were requesting additional witness letters.
Yeah, like Danny Garrett that's mentioned in here, in the letter. And then is also on the witness or confirmatory list. Danny Garrett would be this one.
So we don't have those. I'll just say that right now, and I'm trying to remember if that's something I remember maybe talking about. I don't remember if that's something I should have done, and I dropped the ball on. I think. I'm.
Let's see, well, of course, we felt like medically that there was an ulcer in a dog's eye and he prescribed Neopolydex, so something with steroid. It didn't matter apparently in the beginning because at least according to him, the dog came in without a knee collar and they've been using Mepiricin. The owner's on the Mepiricin for some other issue. They've been putting that in the eye, you know, and so supposedly according to his rebuttal, they recommended the dog go to see an ophthalmologist immediately, and she declined. So that was, I think, part of our issue was that was a big time, he said, she said, you know, without any corroborating, you know, someone had to back us up on, you know, who is more accurate, because, other than the mistake of putting dexamethasone, Neopolydex in a dog's eye that had positive fluorescein stain. That was a mistake, but beyond that,
I was out.
yeah, that
Yeah.
so.
Well, and I think, yeah, I think both of them had listed other persons that could corroborate. And specifically, I think we were thinking maybe Dr. Drake Martin. We have his receipt, like the medical note, but nothing, no statement from him. Excuse me. But yeah, it was a he said, she said without some sort of additional information.
It says a motion was made by Dr. Clarifine and seconded by Dr. Kate Williams and passed to recommend this discussion be tabled with the specifics of facility inspection and with statements based on the collaboration. That's all I had for it.
Okay.
So there wasn't anything about.
I think it was that statements based on cooperation.
That's what it was.
So. The table it again.
That is an option.
I mean, what are the odds that we're going to get statements from the other three parties? I mean, we were hoping, I guess, to get statements from Danny Garrett, Courtney Bowley, and Dr. Martin. And we received none from any of the three, right? Or doubt the ability to corroborate any of this. It's kind of like his word against hers. I'm not calling a member of the public liar, I just can't determine. You know, if you've gone to his facilities and it was filthy, you showed up unannounced. And you were given a full tour. And it would seem to me that that one statement would be, I'm not saying it wasn't filthy when she was there. It's just, there's nothing to corroborate that either. Right? In my mind, we either go ahead and get those statements or we rule what we got. What do you think?
Yeah.
Mhm. Professional conduct stuff, and again, you know, the problem is without someone else, you know, we're not allowed to judge this on a body. We have to judge it on a case by case basis.
So Tanner, help us out there administratively. So who would do a follow-up on like that to reach out to these persons? Because you'd have to go into the context of the complaint and the response. And ask them, you've been noted that you know about this. Can you tell us what you know about this? Is that you or Candace?
It could be either Candace or me, you know, not I do that, not the ability, follow up on that, just have to pass there. We can see like how the target complaints, compiling with you and all that, she can do it too.
So maybe help draft a template letter for, you know, for
On
further,
that, yeah, to request
further statement.
Yeah.
Yeah, I think we should try to get records from Dr. Martin. Yeah, and
He said, she said.
can we also request from the Stanley Garrett, because he was the one who came, I guess, make that with the dog the first time.
Can we just go across the board, everybody that is mentioned?
Sure.
Was Danny, Courtney,
Yes.
Cody, Drake Martin.
And this is a learning process for me as well. For any of the DVMs, can we just make an out request for their medical records?
Yes, please.
Yes, I found that out yesterday.
We just, anybody,
At least I know you can ask double tree veterinarians. And I don't think there's no HIPAA for animals. I don't see anything. What we have, we're signing the consent form for the patient or the owner of the dog or cat or horse or anybody. And I make sure to also probe to the person I called yesterday, like, do y'all have any sort of forms that you need to send to somebody to fill out, anything like that? They said, no, I'll just shoot it to you. I was like, all right, get a little bit more credibility since we're part of the state and governing this, so. Yeah, we can ask.
So would somebody like to put that in the form of a motion?
I propose a motion that we table this once again. This case, pending the, pending witness statements from Danny Garrett and Courtney Bowley, as well as a medical record from Dr. Drake Martin. We can kind of ascertain a few more details about this case.
Is there a second?
I'll second.
Is that Dr. Kate? You guys are in shadow. I see just the white background and then like black figures. So trying to make sure. So we have a motion and a second to table this, this docket number 2024-04, pending witness statements from all witnesses listed within the files, as well as medical records from the, Dr. Drake Martin. We have a motion and a second. Is there any additional discussion?
Oh, yeah. Can you see it's better now?
Yeah, it kind of comes and goes, just based, I think, on some of the light, but, oh, that's better now.
Good.
And then it's back off. Oh,
Yeah.
Is there any additional discussion on this docket? Hearing none, all those in favor of tabling this docket, say aye. Aye. All opposed? Motion carries. We will hopefully take this one up at the next meeting. Okay, let's see. This one is tabled. Next, I have 2024-06. Would someone like to summarize the case as we get started? Dr. Connor always does such a good job of that.
So basically, the crux of the argument is that Dr. Van Pelt was unprofessional. She was rude. She was basically not a good vet and behaved poorly towards Miss Atwater, who has PTSD and a few other things going on. And that basically Miss Atwater is accusing Dr. Van Pelt actually of saying, you need to feed this dog. You need to feed the dog was so she came in and she basically asked what the service dog vest was about. So, oh, no, she did not ask, excuse me. So she was, didn't really pay much attention to the fact that, the dog was a service dog, and she told her that Ellie, the dog's blood sugar was a 79. And she recommended that she feed the dog and then, skip the insulin that evening, which I thought was appropriate medicine. And then recommended she return the next day to have it, rechecked. And that seemed to be the only real interaction between Dr. Van Pelt and his client. And then, client was upset for whatever reason, said one or two bad words about Dr. Van Pelt. And because of that, later, Dr. Van Pelt had basically refused to see her as a client just because she didn't want to see someone that she felt was rude and disrespectful. And then the Vetco business chose to fire her as a client, and send her somewhere else. So I couldn't find anything that Dr. Van Pelt did that I would consider, I'm very sorry for Mrs. Atwater, you know, that sounds like a situation she has personally, you know, and her medical issues and not trying to make light of that at all, but I do when I just judge it directly on Dr. Van Pelt, who has a complaint against her and her very minimal interaction with this customer. I personally would say there's no case here. I'd actually make a motion to dismiss.
Is there a second? Any additional discussion? I would concur with you. I didn't see much. My note was, she said, no issues in medical care.
I'll second it.
So we have a motion and a second. Any additional discussion? All those in favor of dismissal of docket 2024-06, say aye. Aye. All those opposed? Okay, motion is dismissed, or docket is dismissed on 2024-06. Okay. Our next item is docket 2024-08. This is Deborah Trotty with against Dr. Kevin Reed.
Yeah, right. So this is a case regarding a dog named Sarge who was boarded at Dr. Reed's clinic for a period of time. The time had to be extended due to the owner's circumstances, so the dog was there longer than planned. The owner alleges that when she picked up the dog, that his beard and eyes were matted and closed with food. He had open sore on his back hip, and also failure to give 16 doses of his medication while in their care. And then he had also lost weight. The response was that basically, yes, all the medications were individually packaged, but when they refilled it, they went ahead and crushed the medications and put them back into the owner's packaging just for ease of use. So basically refilled those packets. They also stated that they had offered several times for the dog to be groomed, since they did agree that he was kind of dirty, and offered to groom for free. They said the owner did not mention anything about the sore on the hip when the dog was picked up, or that the dog had lost weight. And they affirmed given all doses of medications as prescribed. I think my only thought on this one is basically they made a boo-boo in refilling the owner's packets. I do see like the invoice shows that they invoiced out new medications. You know, there are statements saying that, you know, that they offered several times for the dog to get groomed, but the owner declined that. I don't think they should have put the medications back in the packets. I can see where that was very confusing to the owner. I could see how she could think that. But I mean, kind of, that was my takeaway, was that was their real only boo-boo.
Yeah, in my opinion, I agree. I thought that was kind of strange, but I could kind of see here giving it to the kennel help to say, this is what you need to do, and that making it maybe easy for them. I thought the response was very complete with witness statements throughout the clinic to ascertain what they saw or what they did. So it's kind of hard to go against the he said, she said when you've got that. I also think if you pick up your dog and it's nasty and matted and you think it feels lighter, it's not a huge dog, so if it loses 4 pounds, you're going to notice that you would probably say something in the clinic or take it out to the car and go, wait a minute, this isn't right. I gotta go back in and talk to them about this. You wouldn't drive, put it in the kennel all the way home. And then there's a whole comment about like the kennel had been in the car and she went back in later and got it out. And it was like, I didn't really know where that came from, but to me, it didn't quite add up.
Yeah, she mentioned there was vomit in the kennel. I mean, it's possible the dog got motion sick.
Yeah.
On the way home.
Remember too, her friend came and visited the dog
Daily.
multiple times
Yeah.
while the dog was staying there for the 2-week duration. So the friend would have seen the lack of care
Yes.
and the dirty dog that was crying. And then the other one, most importantly, the complaint is against Dr. Reed. Once Dr. Reed did the exam, the vaccinations, the part that Dr. Reed was contracted to do, Vet Care owns the clinic, not Dr. Reed. He's an employee. So once Dr. Reed finished as the employee doing his physical exam, his vaccination, you know, that on intake, Dr. Reed's part was done. So Dr. Reed, if there was mismanagement by the kennel, if there was mismanagement by, I realize the veterinarian on staff is kind of the boss, they're the captain of the ship while the ship is at sail. But if Mrs. Reed has, or excuse me, Mrs. Truddy has a complaint, it probably is against the facility, not necessarily Dr. Reed. You know, so Dr. Reed's job was done after he did that cursory exam and
Do you know if this is a corporate practice that brought him in as an employee?
Southwest Vet Partners, according to this, owns Vet Care and he's just an employee there.
Okay, it's not like he still has a majority share
Well, I
and
couldn't tell you
80%
that.
owner and.
Well, there's nobody that's gonna be the 80% owner, but he
Yeah.
might be
But
the.
I know like some of the corporations, like you're still like a 60% owner or something, or
Well,
whatever.
yeah, 40 or 20 years.
Yeah, oh, you're still an owner.
Yeah, so I guess there would be a situation where he's liable as a business owner, but as far as him mispracticing or malpracticing as a veterinarian. Right, and then the dog weighed 11 point something pounds, and later, even when I went to see the veterinarian in Truman, it was not 7 pounds, it was 11, you know, it had lost a tiny bit of weight, a small amount of weight.
Yeah.
So, and then all of the other stuff that happened was a month to 2 months later, right? There was that. So. May and June, yeah, so a visit in May and then a visit again in June. So,
I can hope this is just a license learning phase, like, hey, maybe we need to have boarding paperwork while they're here. Maybe we should refill into the same packets, but I don't see anything that we need to touch on. Yeah.
that would be my thought, that this would at most be a civil matter, at most. And, this customer is free to give a 1-star review and then take them to small claims court, so to speak, but I really did not see any level of malpractice by Dr. Reed.
Yeah, she asked for her money back and it's like, that's beyond what we do, so. I would move to dismiss.
I second that.
We have a motion and a second to dismiss docket 2024-08. Is there any discussion? Hearing none, all those in favor say aye. Aye. All those opposed? Motion is, or case is dismissed.
You might be about to get to this, Dr. Brown, but there's also a 2023-06 that we tabled last time.
Yeah, I think, Candace, is that the one I asked you about?
Yes.
Okay.
And so Tanner and I both have spoke with Doubletree, and they're supposed to be sending, medical records, I believe.
We wanted records from Chanel.
Those, Doubletree, what's that? From the doctor. We went back, I believe we did this, there was recording, it was. You found Doubletree, right? We'll talk about that, right?
Yeah.
I called.
Yes.
Yeah. Chanel too, I thought we were Doubletree, and we, it did come upon us, a couple days ago, and I said, hey, I'll go ahead and call the hospital, so maybe we can get there and get done, because it should be my job, personally, treating the attorney, I can talk to folks on the phone, get them to give me stuff really quick if I need it, and so what they did send from Doubletree looked like just invoices, and the invoice from the certificate and a certificate from our vet lab. Which I thought was strange, because I talked to somebody who eventually sent this. Candace had talked to the doctor yesterday, and they were supposed to get us records. So I'm wondering if Doubletree been treated for a long period to get records, because I know that they sent information, blood test over to that whatever federal testing compliance body that was the doctor is having issues with. And let's see, I don't. There,
I guess for Chanel, so this was the one that I recused myself from, because I was sitting next to the doctor who was handling it. I wasn't the doctor, but I was like
That's right.
in the room. And I wasn't sure if I should recuse myself or not, but I do know that Chanel basically picked up the basketball and carried it, got it. They were like the second half of this case.
Gotcha.
With running tests on this bird, evaluating there was communications between Chanel and Doubletree. And so I thought, even though like I shouldn't rule on this, that information would be valuable.
Yeah. We might not have had a quorum to vote on this day anyway.
Exactly. And that's why I kind of wanted to bring it up, because I didn't want us to miss opportunity to request those things, so we'd be ready to go next time.
At least we never got foot in the door and get over it.
Well, I don't know about that.
We have everything from Dr. Vet.
It may be, we have complaint, we have response, we have, I think what initially sent.
Yeah.
And then for some reason, invoices, extra invoices, I don't know, that's all I was wondering.
A lot of vets send that as a medical record.
And I will ask that you call back and see, I got that late yesterday, and I took up my child from daycare at some point, we're at campus, and, I'm gonna run around to the committee meetings all day today, so. We called, it's actually, I'll see, hey, is this the sum total of the records that you have? If so, that may add up pretty close to the complaint as far as not having records, but, also should all do that. Go back to them. No worries. No worries.
And it's mentioned in here, so I mean, it's.
It would be helpful to know when DoubleTree got the results, or if they were told a month ago, hey, this has been unsatisfactory sample, or, you know, you need to resubmit or whatever. If it was, no, they're submitted, it's noted, and we documented, and we bought review once a week for 6 weeks. And you just finally got it, and now here you go, now your client, someone, well, here's your stuff, that's, you paid for it. Maybe they can help you finish the document.
Yeah.
You know, so that could be completely innocent, or it could be something that only seems sloppy. Yeah.
Is that?
DoubleTree.
Okay.
Yeah, with the Dr. Troll chapter. I guess I motion to table it, pending receiving full and complete medical records from DoubleTree and.
I don't think we need a motion. I just think we need to make sure it gets onto the agenda next time.
And you're recruited, so you can't move on.
Oh, that's a good point. Okay, fair enough.
There you go.
But it was on both of our checklists for today.
Slap me on the hand or.
And if need be, we can do a special Zoom meeting when we know that we might have a quorum at a time that everybody can come back, and so we can get this, both these done very quick, or as soon as we get statements in, as soon as we can on the other one. That one may take a little bit longer, just to see if we have the permission to actually tell them this, or, you know, say, hey, you talk to these folks, we'll reach out to them. Or we just call them, since they were going to have their name put down. Testify to this. It will here tonight, but we'll figure out what's the closest way to get that.
Any other business? Dr. Moffat, do you have something, or is that a different topic?
I'll just make sure the facility inspection was taken care of.
Oh,
And that was
okay.
You wanted everybody on Zoom, wanted public record, say, look at my checklist.
Yeah.
I've had it once down, I've worked hard, which it did, all this happens pretty. Makes life a lot easier for inspectors.
Very good. Seeing no other business, we will move on to scheduling the next meeting. Excuse me. This is purely, I think we've been doing these quarterly basis, so we're looking at December, I'm assuming.
Yeah.
Yes. So purely from a selfish standpoint, because I already have to be in Little Rock on the 2nd or the 12th. Any chance Wednesday the 11th works for folks?
That would be great.
Looks open on my calendar.
If I could avoid driving to Little Rock with back-to-back weeks, I always like that.
And while we're working on calendars, the commission meeting is being scheduled for October. We're thinking maybe that second week of October is a commission meeting, and then in November, for the 5th, we have a hearing. And it's I told the one, I don't know that there's anything in particular that you need to be in attendance at. You're welcome greatly there. We'll be at the fairgrounds, the October regular quarterly meeting. And in November will be a special meeting, for a hearing, which, my understanding is you're requested there and perhaps you might need to give testimony. We know that you have seen the case and you can't be a part of the hearing per se itself. But you may be called on for testimony.
That is a possibility, you know, and we're also looking into the best way to gather expert witnesses of certain things. This particular veterinarian has 6 different dockets on those 2 days. It has about 4 counts of charged, this, how do you pronounce the rules? Whatever 19F is, conduct, you know, not generally accepted in the veterinary medical profession. And I finally read a case and that requires expert testimony to set a standard of care for that particular treatment or action that is alleged to violate their sort of general procedures there. That was kind of odd to see in rules because it's slightly different in human medical malpractice. And there's also veterinary medical malpractice, which is also different than this particular rule. So I think researching, trying to figure stuff like that out, and any of you, especially y'all are not, also not commissioners at the exact same time, may be called upon to testify what your thoughts were in this committee. We thought there was a standard of care that was not met, what that standard of care would be, and if this particular veterinarian did and why fail to meet that particular standard. And there's no report. Yeah, those are very important days this year. So, but that was not just because I would be the attorney there, but because it's the Arkansas Livestock and Poultry Commission. It's in between muzzleload and modern gun season, and it is before Christmas. It is before legislative session starts in early January. And even though these are 2 voting days here, that was over on the attorney's calendar, Patrick's calendar, my calendar, all of that. The Deerson's thing was just a joke, but we did have to think about it being here in Arkansas. So water gun starts that next weekend. So
do you think the
Football.
likelihood is high enough we would get called, like that we should go ahead and clear our schedules for those days?
Well, it's not here, let's, he'll be
Yeah.
I think we can always hear the person who's not here, that's how that
yeah,
typically works.
yeah, motion second.
No.
I can do it. But
Is there,
y'all will know that probably within the next week.
Okay.
Because I'm trying to finalize what procedure we want to do as far as expert testimony to hear
that was,
because it's been a while since we've had something like that. Even the board, it's been a while since the board had something like that. So I'm trying to.
if we could look into the future and say, okay, we're probably gonna need some expert witnesses on this, and then reach out to the committee and say, which one of y'all is the best one on this?
Would we need experts outside of the committee?
Perhaps on some of these, and I don't know if we can discuss details of it. There's one in particular we may need to go outside of the body.
And I've already been called, I'm trying to follow it.
Expert.
As an expert.
Yeah. That wouldn't be one of all 3 members. Or all of them. But these are spread out over 2 days to four of the 6 have that standard, I think.
Can we suffice to say that someone needs to represent the committee in general there?
Perhaps,
We would like
it wouldn't hurt.
That's not testifying.
That may or may not be testifying, but we're still working through the nitty gritty of this. The committee passed this up to the commission. Now the commission's having a hearing on it. What would the commission like to have ready from this line, from this committee gathering? That, you know, do you want all of there that touch this case? All the way to, we at least need one person for every case. And if there's one person that can touch, has touched every case and they can be there. If that will suffice, to give everybody a heads up and be mindful of your time and your agendas.
That's what you need.
Okay, but that's why I was looking down the road, there's some stuff coming at us, so the train us, they're both going in the same direction.
That's good. I guess.
It
Depends
doesn't
on how
help.
many hours or away from us, I
It
guess.
helps here.
If it's standing still, it's good, one or the other.
Eventually both.
That is the fourth and the fifth, fourth and the fifth. Here.
What was the fourth and the fifth?
Commission hearings,
Commission hearings.
November fourth and fifth?
Yes.
Okay.
Here.
Yes.
FYI, I am gone those days. I'm out of the town.
no, you had that ready too quick. So, we're gonna need some doc-
That one's an easy one, is the fifth is my birthday, and a couple weeks ago I booked myself a trip. So
Did you say that you'll be out of town in Little Rock?
I will not. I will be in Austin, Texas.
Motion to preemptively sing happy birthday.
So we've got our next committee meeting, December 11th, commission hearings, November 4th and 5th. Any other information we need to let everybody know about? Dates? Any other business to bring before the committee? Candace, thanks for adding the details to the agenda. That was a big help for me as I was trying to go through stuff and keep it all straight in my head of what we needed to get through.
Okay,
Thank you.
just make that part of it if it helps everyone.
Helps me. I appreciate it. Is there a motion for adjournment?
I'll move to adjourn.
Second,
I'll second.
discussion? All those in favor? Aye. Aye. All those opposed? Motion passes. Thanks, everyone.
Thank you. Everybody put, watermelon in your pocket.
They do.
Thanks, guys. See ya.